Thank you for joining us for our free Thursday webinar. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate in Queensland, and I'm your host. In property law, understanding the correct procedures before taking legal action is crucial. Michael Kleinschmidt from Bugden Allen is with us today to guide us through the process for authorising property litigation. Gain a clear understanding of the practical steps your owner's corporation or body corporate needs to follow when contemplating legal action. Today's webinar is national, so we remind you of each state's different terminology and strata legislation. Owner's corporation is also referred to as body corporate or strata company, and the strata or body corporate committee is also known as the strata council, depending on which state you're joining us from. As LookUpStrata takes our transparency responsibility seriously regarding partnerships, as I mentioned at the beginning of the session, in addition to owning LookUpStrata, I own Tower Body Corporate in Queensland. Now, before we begin, I'd like to mention that the information in the session, including the discussions arising from submitted questions and chat conversations, is not advice and should not be relied upon as advice, and you should seek independent advice before acting on the information contained in this session. We're very happy to welcome back Michael Kleinschmidt, partner at Bugden Allen Group Legal. Michael has specialised in strata law in Queensland for over 20 years. After establishing Stratum Legal, Michael joined forces with Bugden Allen in 2023. Michael is a fellow of the Australian College of Strata Lawyers, or ACSL, and is presently a member of the Council of the ACSL, and he's also a member of the legal panel of the Australian Resident Accommodation Managers Association in Queensland, and a long-time member of SCA Queensland. Michael holds a Bachelor and Masters in Law from the University of Queensland and a graduate diploma in Urban and Regional Planning from the University of New England. Michael represents ACSL on the Commissioner for Body Corporate and Community Management Stakeholders Group and the Attorney General's Community Titles Legislation Working Group. He writes on practical strata subjects for trade publications and websites and regularly presents to industry groups and is an active contributor to strata law reform. Michael has acted for almost all of the different stakeholder groups in virtually every conceivable strata matter type. Michael's past sessions with LookUpStrata have always been entertaining and regularly controversial. So thanks for joining us again on today's session, Michael.
Thank you very much, Nikki, and thank you to LookUpStrata for continuing to provide the opportunity to present, and also for the excellent content that you arrange and make available to everyone. Thank you for the opportunity, and our topic today is proper authority to commence litigation. How to avoid losing the fight before you even get started. Now, I suggested this topic because of a recent case that's been handed down in Queensland, which I'll give you a citation for during the presentation, because it makes a pretty good read for committee members, especially who are trying to get litigation commenced quickly, usually because of urgency, and they're worried about the consequences of that, because it can be quite scary. So I will hit on that in true webinar form at the very end of the webinar. What we're going to do on the way through, and given that this is a national webinar, is to cover 4 states. I'll be covering Western Australia, Victoria, New South Wales, and then Queensland in that order. This is about bodies corporate or owners corporations commencing litigation. It's not about individuals or other companies doing so. That's what we're concerned with today. The second question is, what level of approval is required? Does the venues, that's the venue of the litigation, so a tribunal or a court, dictate the level of approval that you need? Well, what if there's some urgency? And are there any tricks and traps? So they're the questions. So without further ado, let's get stuck into them. We're going to start with Western Australia. So what steps are required to commence litigation? Well, the WA State Administrative Tribunal has jurisdiction in relation to most strata disputes in WA, the main exception being debt recovery matters, which are dealt with in the relevant court based on the size of the debt being recovered. Now, the State Administrative Tribunal requires any application that is commenced by the strata company, which is our equivalent, obviously, of the body corporate or owners corporation, to be accompanied by evidence that the application to the tribunal was authorised at either a meeting of the council of the strata company or at a general meeting of the members of the strata company. And that evidence is usually provided in the form of minutes of the relevant meeting. So you've got to have the meeting, you've got to produce the minutes, and you've got to be stapling those minutes to the application to the SAT. Now, there's no similar requirement where a strata company is responding to an application in the SAT. So if you're the applicant, you've got to have that authority and have the minutes. If you're the respondent, you don't have to provide the SAT with that information. Now, turning from the tribunal over to the courts don't have the same requirement for evidence to support the strata company's authority to commence or respond to litigation. Now, in relation to the question of the vote required for a council of owners or the strata company to be properly authorised in relation to those legal proceedings, there's no specific provisions in the WA Strata Titles Act 1985 to require a specific kind of vote to authorise commencing or responding to legal proceeding. So given that there's no specific requirements in relation to a particular type of vote, what other things do you need to think about? Well, in the context of litigation, obviously people will say that it's expensive, both in terms of time, emotion, and money. And one of the reasons it's expensive is obviously you're spending money on legal fees. So the next question then is, well, what about authorising the expenditure in relation to court costs, legal fees, etc.? Well, in general terms, if there's an amount provided for in the budget already for the expenditure, even though it's not specific to the particular proceedings that you're looking at, then the Council of Owners can authorise that expenditure. So that's pretty handy. The Council of Owners are also able to authorise expenditure up to a certain amount above a budgeted amount, dependent on a number of matters that are specific to each scheme. And if that sounds like you, then you need to get some specific legal advice on it, because it does come down to individual circumstances. If the expenditure is not budgeted for, so if your legal expenses are not budgeted for, or the amount of the expenditure is above the amount that the Council of Owners can authorise without a budget or in addition to the budgeted amount, then you're going to have to go get authorisation by an ordinary resolution of all the lot owners in a general meeting or a vote outside of a general meeting. So the second question then is, well, does the venue dictate the level of approval? Well, in WA, the answer is no. But as I've indicated earlier, there is this evidential requirement for proof of authority to commence if you're in the WA SAT, and you don't have that requirement if you're in a court. The next question then is, well, what about urgency? What happens if the proceedings are urgent? And just for everybody's information, like the most urgent proceedings I'll usually see are things like unauthorised building that is taking place, usually renovations within someone's lot. I've also seen very urgent ones where support has been removed or a crane is about to swing over the land without approval. So you can think of circumstances where there's either going to be a trespass or there's some structural risk and you really want to get started straight away, not next week, but tomorrow. That sort of level of urgency is actually quite common. Well, in WA, the Council of Owners can authorise the proceedings pretty quickly, but the issue is then going to be, what about the money? All right, so you can get the Council of Owners to make the decision very fast, but what about the money, which is then required to pop up to the Supreme Court to go get the injunction to stop the crane swinging over the top of the land? Well, you can go organise that expenditure at a later date. There's no technical time frame attached to it. If there's money in the budget for the expenditure, then there's nothing further that needs to be done by the Council of Owners. If the budget needs to be changed, however, or you need to raise additional funds, then the Council of Owners will have to take steps to have the budget formally amended and or to raise the additional funds by way of a levy. And again, there's no specific time limits for that. The timing is going to be driven by the funds that are available at the time. Now, I started with WA because that's a lot simpler than the other jurisdictions and it's pretty user-friendly in some respects, which is great. Now, that said, there are some tricks and traps that I'll cover off on very quickly. Now, all strata companies in WA should include in their annual budget, from our point of view, an amount on account of legal fees generally. It sounds strange coming from a lawyer. You should have a budget line item to cover some legal expenses every year. You don't have to spend it, though, by the way. But it's this is a case of prior preparation and planning prevents poor performance. It's better to have the amount there and not need to use it than to have it there and then not have it there and then have to take remedial steps. So we recommend that you have an amount in your budget to cover legal fees generally, even if there's no proceedings contemplated or issues that have arisen. What that does is it gives the council of owners the flexibility to commence or respond to proceedings without having to go to a general meeting. Lawyers should guide their strata company clients about these requirements early so that there's no delay in commencing proceedings, for example, in the State Administrative Tribunal, if that's where you're going to end up. All right. Now, my special thanks to Carolyn Megan, our Bugden Allen Special Counsel in WA over in Perth for that information, for that summary. Let's turn now to beautiful Victoria. And our first question for Victoria, again, what steps are required to commence litigation? Now, I'm going to roll up the first three questions with this summary, and the next two are the level of approval required and venue considerations, because the Victorian legislation is a bit intertwined with respect to those first three questions. So, in relation to an owners' corporation in Victoria, authority to initiate legal proceedings is under Section 18 of the Owners Corporation Act 2006. And what you've got there is that an owners corporation must pass an ordinary resolution to commence civil proceedings where the claim is for an amount not exceeding $100,000. So that's the provision that's most commonly relied upon in relation to debt recovery matters, so unpaid levies, etc. All right. For all other proceedings, so that's going to include things like criminal or quasi-criminal proceedings, and you might say to me, criminal proceedings, what are you talking about? Well, I can tell you now that in Queensland, for example, there is no strata cop in Queensland, and if there are breaches of our legislation, a body corporate can go and prosecute them under the Justices Act. So it is relevant from time to time to consider criminal or quasi-criminal proceedings as well. So in Victoria, for anything over $100,000 in civil or criminal, then regardless of the jurisdiction, you're going to need a special resolution. So that's a resolution passed by at least 75% of the lot entitlements. All right. Now, well, what happens if you don't get that resolution before you kick off the proceedings? Well, failure to pass a resolution prior to the commencement of proceedings is an error that can be cured. And for those people in Victoria, have a look at this case. It's the case of Burbank, Australia, which is B-U-R-B-A-N-K, Australia, Pty Ltd, and it's against an owners corporation. I'll provide the full citation in the materials so that you can post it out. It's a 2015 case, Victorian Supreme Court 160. All right. Now, if the owners corporation fails to pass the required resolution prior to kicking off the proceedings, there is an automatic stay of the proceedings, and that's really interesting. So it doesn't affect the validity of the proceedings, it's just the proceedings are stayed. There's also standard provisions regarding the issuing of a letter of demand prior to commencement of proceedings, which you have to comply with as well. In relation to an owners corporation's authority to respond to litigation, so if it's a defendant or a respondent, ordinary resolutions are usually required to engage and provide instructions to the owners corporation's solicitors. Similarly, decisions regarding filing points of defence, so if you're in there defending the case, you should always support those by way of ordinary resolution as well. It's an unfortunate fact that some lawyers approach litigation from the point of view of sort of playing the man and not the ball. So they will very much look at your processes that you've adopted and try and pick them apart. That's probably trite for me to say that to a lot of people that have been involved in a lot of owners corporation litigation, but it's something that I find a bit odious, but nonetheless, it's there. and owners corporations should really make sure they tick off on the procedural requirements properly so as not to leave themselves open, all right? An owners corporation may also, and this is pretty important, by instrument or by resolution at a general meeting, delegate its authority to pass ordinary resolutions to its committee, to a manager, or to the chairperson. So individual owners, employees, or the secretary may also have this delegated authority. It's just a lot less common, all right? And now, if you're interested in that, you should go and have a look at Section 11 of the Owners Corporations Act for further detail. So our next question then in Victoria, well, what about urgency? What if there's urgency? Well, if you get started without the necessary resolution in Victoria, then there will be a breach of the Owners Corporation Act. In Victoria, penalties for breaches of the Owners Corporation Act do not apply. Now, VCAT, the Victorian Civil and Administrative Tribunal, will generally order, where there is one of these breaches, that an owners corporation cures the breach and pays for any consequential damage which may have occurred because of the owners corporation's act or omission. So just think about that for a second. If you've kicked off litigation urgently without the necessary approval, and it turns out to be a fiasco, you know, it was an improperly formed action, the litigation was doomed to fail, and the other side incurs a whole heap of costs as a result, then the owners corporation can find itself in trouble as a result of that, okay? Now, assuming a committee or a manager has the appropriated delegated authority, then those people can make that decision and can and often do make those decisions to kick off the proceedings. The beauty of that is that you don't need to ratify those delegated decisions later on. Now, that's a major contrast to Queensland, by the way. Queensland, for example, body corporate is not allowed to delegate its authority to individuals. The committee of the body corporate can make certain decisions, which I'll cover later off, but I quite like that delegated authority provision from Victoria. It's quite handy. Now, if there's an error or omission and you identify that, then the owners corporation, so an error or omission in the process, the owners corporation should take reasonable steps to cure the error as soon as practicable. That's because the owners corporation should be mindful of its obligations to act in good faith and to exercise due skill and diligence. Now, have a look at Section 5 of the Owners Corporation Act in that respect. There's some statutory obligations there. Now, in Victoria, are there any tricks or traps? Righto. Most strategic decisions are made by owners corporations with respect to disputes are generally authorised by their committee, all right? Due to time constraints, however, committees generally make decisions by way of circular motions, i.e. emails. Now, those sort of resolutions don't constitute a ballot for the purposes of the OC Act, and therefore there is a basis for asserting that those sort of decisions are null and void. Practitioners in Victoria generally overlook this issue because obtaining instructions could be pretty difficult otherwise. A committee should maintain minutes relevant to all resolutions proposed in relation to legal proceedings, and those minutes should be available to members for inspection upon request. And again, that's making sure that you've got a really good paper trail so that anybody who attacks the process as opposed to the issues is going to have a hard time of it, all right? Although not strictly required, we generally advise that owners corporations bring proposed terms of settlement to the broader membership's attention or consideration for claims valued at more than $500,000, all right? Minimises the risk that members will raise issues with the terms of the settlement or process in the future. With respect to legal privilege and confidentiality, now bear in mind, obviously, when you're dealing with litigation, and this is a problem that I've experienced many times, you're trying to advise the owners in your owners corporation about what's going on in relation to the proceedings and providing prospects. You know, what are your chances of winning? What's the best case, realistic worst case? You know, what are the cost implications? Those sorts of things, which are really crucial questions. You know, what are the weaknesses in our case and evidence, etc. It can be difficult to make sure that the owners are properly informed, but where the other party to your litigation is one of the owners, making sure that that owner doesn't get their hands on that sort of material. I had a case up in Queensland a couple of years ago where that was right at risk. There was an argument being made that privilege had been waived in the communication. We ended up going all the way through the adjudication process to assert and to establish that my pre-litigation advice didn't have to be given to the enemy. And it was, it's something that you need to watch out for. It's difficult. So in Victoria, managers should be mindful not to circulate legal advice to lot owners who are the other side in the legal proceedings. You would be surprised how common this is. It actually commonly occurs. I'm not blaming managers, but mistakes are made, and it can be really prejudicial to the conduct of litigation down in Victoria. Now, my special thanks to Eve Whitmore, one of Bugden Allen's associates in Victoria, for that summary. Thank you, Eve. Turn now to New South Wales. So moving up to where it's slightly warmer. Right? In New South Wales, what steps are required to commence litigation? Well, in New South Wales, the issue is not so much about commencing or responding to litigation. It's actually about hiring the lawyers to help you. There is a specific provision under the Strata Schemes Management Act, which is Section 103, in relation to authority to incur legal costs, which are very novel. Obviously, in New South Wales, they're very concerned about owners' corporations spending money on lawyers. Who would have thought? In any event, under Section 103, a resolution at a general meeting is required to approve legal services, though there are exemptions. It's interesting the provision only refers to services for which payment is required. So if you're lucky enough to find yourself a pro bono lawyer, you're doing well. Don't think there's a trap there though. If you engage a no-win, no-fee lawyer, you notice how it says fees? Lawyers will often charge fees for their time and then outlays for the expenses that they have to incur on your behalf. So court filing fees and stuff like that. So just because someone's a no-win, no-fee, don't think that you don't need approval under Section 103. You probably do, because you're going to be obliged to pay outlays, which is still going to be for the provision of legal services. And legal services is defined in Section 103(5), and it's legal services isn't limited to litigation, it's all legal services. So even though we've been talking about litigation, it's all legal services, be aware of that. Now, with respect to urgent matters, approval under Section 103 is not required if the spending is under $15,000. Now, if you're looking in Section 103, it says $10,000 in the section, or a higher amount specified in the regulation. Regulation 26(1) of the Strata Schemes Management Regulation, the limit is increased from 10,000 to 15,000. So there is a little trap there. Make sure you're referring to the right level of fee. Now, if the legal services the owner's corporation is proposing to engage don't exceed $3,000, then approval under Section 103 is not required. All right. That said, we still suggest that you pass a resolution at the Strata Committee level. It's just a good policy to have. Again, you know, it's about making sure you've got a nice, defensible series of decisions in your litigation so that your process doesn't get attacked. There's nothing worse than having a really good case and have someone attack your process because, you know, that's all they've got left. They've looked at the case, the merits of the case are fantastic, so they turn around and look at your process and try and undermine that. Now, it's also interesting, I find, that approval is not required under Section 103 to obtain advice before you commence legal action. I mean, you would have thought that that's probably the best time to obtain legal advice, but under Section 103, that's one of the exemptions from needing the approval. Now, another curious thing about New South Wales is that under Section 103, subsection 4, there's a specific provision that says that failure to obtain the approval does not affect the validity of the proceedings. So remember, this is not approval to commence the proceedings, it's approval to spend the money on lawyers, presumably to help you with the proceedings. But there is a specific provision that says even if you don't get the approval, that's not going to affect the validity of the proceedings. Now, there's a case called Elizabeth Bay Road, which I'll give you the citation for in a minute, which is something that you can refer to specifically on point. What level of approval is required in New South Wales for the spending on a general meeting resolution? At a general meeting, you don't need a special resolution, all right? And that's in section 103, subsection 1. There are some exemptions, and you don't need approval when the spending is on obtaining advice before commencing action, recovering unpaid contributions, so if you're going to recover levies, and then legal services prescribed by the regulations. There are no legal services that are exempt under the regulations, so you don't have to bother going to have a look. Rightio, committee may approve legal services under $3,000, and again, have a look at clause or regulation 26.2 under the regs. And if there's urgency and the cost is less than $15,000, as I've said, then you don't need that approval under 103. Now, in New South Wales, helpfully, those rules are not affected by the venue that you're litigating in. It all comes down to that question of spending on the legal services. In New South Wales, if there's urgency, you've got that lovely provision that saves your decisions, saves your proceedings under section 103.4. And that's specifically envisaging that owners' corporations may need to act urgently and without approval to spend money on legal services. And what that section means is that even if you don't have the approval, then you don't have to worry about your proceedings being invalid, which is really, from a lawyer's point of view, that's actually really fantastic. Now, that said, you can't sit on your hands, all right? You still have to go get your approval, and you can do that with the lower level approval and then go get the ratification later, all right? But you've got to do that promptly. And this is where I'll give you the citation for that Elizabeth Bay Road case. So it's 2 Elizabeth Bay Road, Pty Ltd versus the owners of Strata Plan 73943. It's a 2014 case in the New South Wales Court of Appeal. And I'll make sure that the citation's available for Nikki to distribute after the presentation. Also a good read. Now, that case was on the wording of the old Act, but the wording is basically the same. All right. Are there any tricks or traps in New South Wales? Well, yes, there are. Mainly they're traps. Things to look out for that you should probably go get legal advice on to help you out with. Well, what if the developer's still controlling the committee, particularly in relation to building claims? All right, that can be pretty problematic. I might add that's not necessarily limited to New South Wales. I'm heartened by the robust activity of the New South Wales Building Commissioner over the last few years. That's, I hope, helped my colleagues in New South Wales say that it certainly made waves and got things moving, which was really nice. The second trap is the strata manager not calling meetings or delaying in calling meetings. Now, there could be genuine reasons for that. That said, if there's delays, obviously the Elizabeth Bay Road case, you can't sit on your hands, you've got to get going quickly. So the clock is ticking and make sure that you're watching the clock. And the final trap there is the question of raising levies. Obviously your authority for the spending is one thing, making sure you've got the money is the other. So you need to follow through on that. My special thanks to my partner, Gerard Doyle from New South Wales for his summary. Thanks very much, Gerard. And now we're on to Queensland. As per usual, the most complicated of all of the jurisdictions, why I love practicing in Queensland. So what steps are required to commence litigation in Queensland? Well, there is one section, which is section 312 of our Body Corporate Community Management Act 1997. Now, I'm going to ignore 2-lot schemes. Sorry to you duplex owners out there. And the general rule there is that if both owners agree, you can do pretty much anything. That's a very glib summary, but it's pretty accurate. So putting to one side specified 2-lot schemes, proceedings can only be started by special resolution unless the proceeding is a prescribed proceeding. So remember, we're talking about starting proceedings now. And the general rule is you need a special resolution. Special resolutions are taken to a general meeting. So you've got to go to a general meeting and you've got your special resolution requirements, at least 2/3 in favour, not more than 25% against, etc. Right? The exception is a prescribed proceeding. So what are prescribed proceedings? Well, they are proceedings for the recovery of a liquidated debt against the owner of a lot included in a scheme. Now, that can be unpaid body corporate levies, contributions, but it could be other liquidated debts as well. So bear that in mind. The second type of prescribed proceedings are counterclaims. So if the body corporate is already involved in litigation and it wants to bring a counterclaim against the plaintiff, so the body corporate's the defendant and it wants to bring a counterclaim. A third party proceeding, so the body corporate wants to blame someone else, or another proceeding in a proceeding to which the body corporate is already a party. So if the body corporate didn't pick the fight, then it doesn't need a special resolution to go and continue the fight. It can rely upon a committee resolution. And that's an important thing I want to say here. Just because you don't need a special resolution doesn't mean you don't need any approval at all. What it means is that you don't need a special resolution. So you still need a decision of the body corporate, and that decision will then most often be made by the committee, unless it's a restricted issue for the committee, all right? Which I won't go into today. The third type of prescribed proceeding is a proceeding for an offence in relation to a bylaw contravention. So if you're kicking off a prosecution, for example, or of a breach of bylaws, you only need a committee resolution for it. And the final type of prescribed proceeding is proceedings, including proceedings for the enforcement of an adjudicator's order, an appeal against an adjudicator's order, or any Chapter 6 proceeding. Now, Chapter 6 in Queensland is where we go off to the Body Corporate Commissioner's Office for a conciliation, a mediation, an adjudication, a specialist mediation, a specialist adjudication. All right, so any of those sort of proceedings you can do on the authority of a committee resolution. All right, so for these prescribed proceedings, a committee resolution is generally enough. All right, everything else you're going to need a special resolution. Now, pause there to say this is specifically about commencing or responding to the litigation. It's not about the spending. So there are the spending of money, whether it's on court costs, whether it's on lawyers, etc. That is a separate stream of approvals that you need to go and approve properly in accordance with the normal spending rules. All right. So in terms of the levels of approval required, a special resolution has to be passed at a general meeting unless you can go get an adjudicator's order to forgive you from it. That's rare, but it can be done. Alternatively, you're doing the approval at committee level, as I've said, for a prescribed proceeding. Now, if you're in a different venue, does it make a difference to the level of approval? So QCAT, our Queensland Civil Administrative Tribunal versus a court, for example. Well, for almost all disputes in Queensland, the answer is no. However, some jurisdictions may require, as part of their case management process, for example, alternative dispute resolution, that body corporate representatives have to be in a position to negotiate or to enter into settlement arrangements, which in turn may require approval beyond a committee's competency. So you've got to be careful about that. Even though you might not need a high-level approval to start or respond, you might need a higher level approval if you've got to go in and be able to do a deal. Now, in relation to urgent cases, obviously, a committee resolution can be done very, very quickly. I have literally seen them conducted within hours to get proceedings authorised. For proceedings that require a special resolution, obviously you've got problems because it's a 21-day minimum notice period plus an allowance for post. Now, under the Commonwealth Evidence Act, that post allowance is now like 10 days. So that's pretty hectic. So in Queensland, it's not uncommon for a committee to pass a resolution to commence the proceedings on the basis that they submit that resolution for ratification at a general meeting later. All right, so that's where you get this, let's just pass a committee resolution subject to ratification later, we'll get started, and then we'll bring it to a general meeting and have it ratified. Now, the ratification's got to take place at a general meeting, unless, I won't talk about the exemption because it doesn't apply under all modules, but typically if you can get unanimous consent. So if you're in a smaller scheme, like 8 or 12 lots, and you can get everybody to agree in writing, then that will typically get you home. Otherwise, you're going to have to go to a special meeting. That's typically going to take 30 days. You should be doing that as soon as possible after that committee resolution is passed. Don't wait for the litigation. Just get it on, get that general meeting on. Your ratification resolution is typically couched in terms of the body corporate ratifying, adopting, and approving the committee's decision to commence the proceedings. Now, there can be some really interesting consequences if the proceedings are commenced on the authority of a committee resolution, but the ratification doesn't pass. That doesn't happen very often, but it can lead to some pretty hectic stuff. And if you're in that situation, you find yourself in that situation, definitely get advice, all right? There is a trap there that if the first return date of the proceedings falls due before the general meeting at which you're going to consider the ratification motion, a question usually arises, well, should the proceedings be adjourned pending the ratification motion? Because we know that what we've done hasn't been properly authorised. It's got to go to a general meeting. So should there be an adjournment? Courts are typically pretty happy to give the adjournment if everything's been done properly up until that time. All right. But if you're looking at things like an injunction to stop a crane swinging over the top of the property, or the neighbour next door is using their big yellow Tonka truck to remove soil that's going to undermine the basement, you really want to make sure you've got your ducks in a row and have that meeting happening as fast as you possibly can. Now, in very urgent circumstances where you need support at a general meeting, but you're not sure whether or not you're going to have the numbers, you can apply to our commissioner to shorten the meeting notice from 21 days to a lesser time period. But that application to the commissioner takes time as well. So you might be able to get that one through in sort of 3 to 5 business days. You might be able to shorten the notice period for the general meeting to like 7 days. So you could get your meeting conducted in sort of 14 days. And I've seen that happen. I've had colleagues who have done it. But there's a lot of effort in that and a lot of cost in that. And you're still taking 14 days as opposed to sort of 30 days. So hence the reason why I say get that EGM going for ratification as soon as possible. All right. Now, tricks or traps in Queensland. I'm conscious to make sure we've got a bit of time for questions, Nikki. Now, if you're relying upon ratification in Queensland, so you're doing that whole, it's not a prescribed proceeding. And the classic example here is you've got to go to the Supreme Court for an injunction in relation to trespass or removal of support. And you've done the committee level resolution, get that general meeting going as soon as possible. The courts in Queensland, most of the time they'll adjourn, but sometimes there have been occasions where they've been loath to do that. And the other thing to remember in Queensland, as I indicated at the beginning of the Queensland section, is that just because you're authorising the proceedings doesn't mean you haven't authorised the expenditure. You've got to do the authorisation of the expenditure separately. And it's one thing to pass a resolution that says, yeah, let's go to the Supreme Court to stop that crane from swinging, you know, pallets of Besser blocks over the pool so the developer next door can build their basement. It's another thing for the owners to then vote no to raise the $20,000 required for legal fees to go and do the injunction proceedings. And that's a pretty light estimate, by the way. That would be a junior barrister for that sort of work. So yes, make sure you deal with the money question as well. And I would mention that for those that are interested in Queensland, that recent decision that I was referring to is only from the 9th of April this year, and the citation is Body Corp for Oceana on Broadbeach and 21 Broadbeach Boulevard, Pty Ltd. And it's the 9 April 2025 decision of the Supreme Court. Chief Justice Boskill gave the decision. That's a really good decision for committee members to have a read of, because there's discussion about ratification and those sorts of things as well. Righto, so happy to take questions. First part of the question is, when do several matters or disputes need to be included in calculated the committee's spending authority? So imagine you've got a series of disputes that appear to be related. And the question then arises, well, hang on a minute, do we authorise the spending on dealing with these disputes as individual disputes, or is there another rule? Now in Queensland, you know, our legislators recognise that the oldest dodge in the books for committees who wanted to exceed their spending limit was to break one project down into a number of parts and then approve each one of the parts within the spending limit. So we have this thing called the multiple projects rule. And basically what it says is that where you, in reality, where you have one project and you're just breaking it down in that fashion, then the spending limit applies to the entire project. Now, if you apply that rule to this situation, when could disputes or litigation be regarded as one project? Well, from a linear point of view, if you had, for example, the preparation and issuing of a bylaw contravention notice, the commencement of proceedings in the Magistrates Court to prosecute the bylaw breach, if there was a failure to comply, you broke down those Magistrates Court proceedings into the issuing of the complaint and summons, and then responding if there was a defence. Now, that would clearly be a breach of the multiple projects rule, okay, because it's one matter, it's one piece of litigation, and breaking it down in that way is artificial. I think you're okay if you break down the two major phases, which is prepare a continuing contravention notice and issue it, right? That's a discrete project, I think. And then the Magistrates Court proceedings, if you go and do the prosecution as opposed to going to the Commissioner's office, and just by the way, I do recommend that you go do the prosecution rather than going to the Commissioner's office. It's for reasons I won't go into. It's not scary, and it's actually a relatively straightforward process if you've got good bylaws. So that's a vertical matter. If you have a horizontal matter, you've got, for example, a special levy that you've issued to everybody in the scheme, and you've got 10 lot owners who haven't paid their bills, haven't paid their levy bill, and you start proceeding against those 10 owners. Would that be one project? In my view, no. They're separate proceedings that are dealt with separately. There might be a question if those 10 lots were owned by the same person. That's a possibility. But even then, and I've had recent experience in this, my view there is that each one of those proceedings is a separate proceeding. And typically when you do levy recovery work like that, I do recommend that you treat each lot separately, because you don't want a payment on one or an error on one to infect the others. So that's that one. The default spend authority of the committee is quite low, especially when dealing with a small body corporate. True. This can become even more problematic when several proceedings arise which have common materials and issues. True. How do we calculate the committee's spending authority in such cases? Well, that's what I've just covered. All right. So it's the normal rule unless you regard it as one project. So then the question then moves into an example. Should the body corporate generally or specifically for applications under Chapter 6 and court disputes increase the committee's spending limit to enable them to deal with multiple urgent legal issues and matters, whether or not a resolution is required to commence proceedings given the project of spending, the project rule? So that question in essence is, if you're expecting problems, should you prepare for it? Of course. Prior preparation and planning prevents poor performance, the 6 Ps. So try and raise the committee spending limit, because you can do that by ordinary resolution passed at a general meeting. And I'm a big fan of having a realistic spending limit in relation to committees. I'm also a big fan of having a reasonable allocation for legal costs in the budget each year, even if you're not expecting trouble, specifically so that it's there if you need it, and the committee can then go and authorise the expenditure if they need to. In Queensland, if you go spend money that you haven't budgeted for, you must, and I emphasise the word must, go and raise a special levy to cover the cost of it. So if you pass a resolution that says, oh, we're going to respond to these legal proceedings and we're going to spend 20 grand on legal fees, and you don't have the money in the budget, you don't have a choice. You must pass a resolution to raise the money to go and spend the 20 grand. The body corporate has a vexatious owner who is a retired bush lawyer. Surprise, surprise. The owner has commenced 5 applications, each seeking interim orders, and followed by exhaustive and lengthy multiple submissions. Again, surprise, surprise. There was discussion in Queensland about limiting the size of applications, by the way. Whilst the applications were lodged separately, they are repetitive and cover common subject matter. Responding to a single complaint would have been under the committee's default spend limit. having to respond to 5 duplicitous applications is going to exceed the spending limit. You know, if we retain 5 lawyers, etc., you know, multiple costs. This is one of these ones where I'd probably see if I could make a procedural application to the Commissioner's office to have all 5 of them heard together, so that you're then engaging lawyers to deal with what is effectively one application, even though it spans across 5. The Commissioners, case managers, and adjudicators can make orders that happen. And I would probably jump the gun on that one, because they're usually pretty good and proactive in recognising that and lumping them together, okay? But I would probably jump the gun on it and try and go and see if that could occur so that they be heard together, so that then you're only spending 1 lot on lawyers. You're not going to spend 1/5, all right? You might spend 2/5. It'll still be cheaper, but you won't be spending 5/5.
What specific steps can a committee legally take to initiate action quickly when faced with an urgent issue? And what are the potential risks of using these expedited procedures instead of the standard process?
So, look, as a general principle, I've given in the body of the presentation, and the reason that I did it jurisdiction by jurisdiction is so that people looking back over this webinar can go to their state and listen in specifically for the rules that relate to their state. It's not legal advice. It's for education and information purposes. You start there, then you go get legal advice if you haven't already got it. And then you can get information specific to your state. However, the general rules, when you extract and you look across the entire spectrum, if you take the most urgent circumstances that you can think of, which is usually where this question arises, you know, there is literally a crane transporting pallets of Besser blocks over your swimming pool that your kids, you know, and your neighbours' kids swim in, then the least that you should be doing is getting the committee of whatever type it is together, making a decision to get going, and that's typically to commence the proceedings and to authorise the expenditure. Get in contact with as many of the lot owners as you can in advance of that meeting. Invite lot owners to attend. I mean, it's going to depend. I mean, you have schemes that have 500 units in them, and you have schemes that have 5 units in them, all right? Typically, you know, there's this common law doctrine called the doctrine of unanimous consent. If you're in the fortuitous position of having sort of 20 or less units and you can get everybody to agree on something, then that common law doctrine, and again, take this with a grain of salt, will typically keep you out of hot water. But if you involve as many people as possible, get that initial proper committee decision made, even if it's beyond the committee's competency and power, it's still a decision of a decision-making body of the owners corporation or body corporate. Get going, you know, engage the lawyers, get the proceedings going immediately with the assistance of your very competent and capable body corporate manager, you know, strata manager. Get that ratification process going as well. There's this thing, obviously, analysis by paralysis, you know, paralysis by analysis, okay? The law, you know, I've been fortunate in my career to be exposed to some really thoughtful and intelligent judges. And I'm happy to say in Queensland that most of them are still very connected to reality. And they understand that we have a pretty prescriptive set of legislation, and that people are people and people have human problems, and that just, you know, you see a pallet of Besser blocks being swung over your swimming pool, it's perfectly understandable that you lose your mind at your neighbour for that sort of behaviour, and that you get proceedings going, as long as you can show that you've acted in good faith, typically without negligence, and acting without negligence is also then getting a legal advice as quickly as you can. But don't slow down. You know, my recommendation is do all that stuff contemporaneously. Get your fellow lot owners and committee members to help you out. Get some decisions made. Get the ratification processes going. Now, obviously, you want to be in the right on these things. I'm not talking about stuff that's questionable, that you know is questionable, or it's flying a kite. You know, we're talking about legitimate breaches of rights and obligations, okay? I mean, a few years ago, I was acting for body corporate here on the Sunshine Coast who was negotiating with a developer neighbour about making sure that the building didn't lose support when the developer neighbour was going to excavate the basement for the neighbouring new community title scheme. The agreement was fully prepared and ready to be signed. And we were waiting on the signature to come back from the developer. And that afternoon, the yellow Tonka trucks came in and just started, excavating. The agreement was never signed. And it was abysmal. And I turned around to the body corporate and I said, right, your remedy is to go to the Supreme Court to get an injunction because he's removing support and he's trespassed on your land. And by that stage, obviously they'd spent money on the legal process up till then, and they were wary of going to the Court of Appeal. Sorry, going to the Supreme Court. And they had a perfectly winnable case. They were in the right. And funnily enough, because of that particular case, I now have a different way that I recommend that owners, corporations and bodies corporate negotiate with neighbouring developers about cranes and subterranean access. I now recommend that you actually approve the injunction proceedings at the very beginning. The moment you get the letter from the neighbour that says, oh, I'd like to swing a crane, an unloaded crane over your backyard for 6 months, or I'm going to excavate down and I need to put safety barriers on your side. The first thing I recommend that the body corporate does is to pass a few resolutions, which I've drafted, which say, happy to do a deal with you on these terms, according to these principles, and they're principles, they're not terms, they're principles. Happy to do a deal with you based on these principles. And we now authorise proceedings to commence in the Supreme Court if you trespass. And every time I've done that with the developer, and I've said, right, here's the way this is going to play. I have pre-authorization to negotiate a deal with you according to these principles. But if you do the wrong thing, then we're off to the Supreme Court because you'll be trespassing. Every time we've done it, we've done a deal and it's been on good commercial terms. So anyway, I digress, but that's an example where, and it's some people say, oh, you're just bluffing. Well, and that's the irony, getting lot owners to the point where you say, the best chance of avoiding litigation and avoiding court is to authorize it now, because I can tell you, based on some research I did a while ago, a good 10 years ago, the minimum amount that a Supreme Court would order you for damages for your developer neighbour trespassing was about 20 grand, all right, plus costs. So a little injunction like that to stop a swinging crane might be 40 grand. You get 20 grand back. It almost becomes a self-funding exercise. So anyway, I digress, but they're the ones where you usually get really big circumstances of urgency.
Okay. Well, we're coming up to the end of the session, Michael, now, but I might just, before we finish, we thank you very much for presenting. I think this will be a great resource for everybody to come back to. Do you have anything that you'd like to leave us with, just some final words before we wrap everything up? And we thank you very much for your time today.
Oh, look, no trouble. Even though, and thank you. Even though we've been talking about litigation, I'm not primarily a litigation lawyer. I do quite a lot of litigation, but a lot of my practice has been development management rights and providing advice to bodies corporate as well. And these days, a lot of administrations, I administer dysfunctional bodies corporate and or dysfunctional lot owners and quite enjoy that work. So I've got a pretty broad experience. And what I want to say to people about litigation is it's just a tool like any other tool, right? And just remember that when you go to a lawyer, I always say, when faced with a problem, a carpenter reaches for a saw, a plumber reaches for a wrench, right? The person that you go to will reach for the thing that they are most used to. So if you go to a litigation lawyer, you'll end up in litigation. You go to a commercial lawyer, you'll start with commercial. That's sort of a general rule of thumb. Litigation is just a tool, but it's a tool that shouldn't be overused or underused. You should really think about it. Litigation is difficult, it's expensive, it's emotionally exhausting. But in my wide experience, there are people who know that and they play that, and that's what they use against you. They're daring you to litigate against them. you know, my detector for those people is now fairly finely tuned. So as a lawyer, I will say to my clients, this guy is having you on. He knows that it'll cost 20 grand to go and sue him for something that's worth 5 grand. And then I'll say to my client, are there other ways that we can skin this cat? You know, is there a way we can avoid it? And if there's not, then, you know, is this worthwhile? You still have to look at it rationally. But the other thing I'll then say is, obviously, you know, with some of the cases that I've run that have been pretty novel, because that's the other thing I like to do is run novel cases. You really have to pay attention to the process, because in those novel cases, you get lawyers on the other side who become quite concerned about the fact that the cases can be quite volatile. They're very difficult to predict the outcome of. And so in that uncertainty, they'll attack the process. They always attack the process. So you really got to make sure you've got your process lined up and very well dealt with.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.